So welcome everyone to our webinar on the Additional Support Needs Tribunal and support for families and young people. We're delighted to see lots of you here tonight. My name is Annie. I'm the Senior Advice and Information Officer at Enquire, and I'm joined tonight by Iain Nisbet from Cairn Legal, who's here as part of his role in the My Rights, My Say service, and Chloe Minto from the Government Law Centre, who's here in her role in the Let's Talk ASN service. So they'll both introduce a bit more about themselves in a couple of minutes. In the background, we've also got Kat and Hannah from the Enquire team. So they'll be putting up links in the chat to kind of resources and websites and things that we mention. And they'll also generally be keeping an eye on any questions that might pop up in the chat. So the plan is that I'm going to give a brief introduction to Enquire, and then I'll kind of explain a bit about what we're going to do in the session today. And we'll then get properly into the subject for today about the tribunal. So Enquire, as some of you might know, is the Scottish advice service for additional support for learning. We've existed since 1999, so over 22 years. We're funded by the Scottish Government to provide independent advice and information to children and young people, parents, carers and professionals about children's rights and the legislation and guidance relating to additional support for learning in schools and nurseries. And as this slide says, our vision is that all children in Scotland are supported, included and listened to throughout their time in education. So some of you might know a little bit about what we do at Enquire already because you're here tonight, but for those that don't, so we offer a helpline where we give one-to-one advice. So we can do that by phone, by email or through web chat as well. We've also got a range of publications about additional support for learning. So we've got a kind of comprehensive guide for parents and carers. And then we've also got a range of, I think about 27 fact sheets on kind of more specific topics. We've got a website for parents, carers and professionals, which is enquire.org.uk. And then we've also got reach.scot, which is a website for children and young people with additional support needs. And we also kind of do raising awareness activities. So things like this session tonight to try and raise awareness of children's rights to support at school and in nursery, and things like through our social media as well. And we do all of this with the goal to help you feel more listened to and supported, to feel more confident to take action, to understand your and your child's rights and the responsibilities of schools and local authorities, to know what steps you can take and to know where to find more information and help in the future. So that is a brief overview of Enquire. I'll just pass on to Chloe and Iain now to explain what they do. So Chloe, do you want to explain a bit about your role?
Yes, good evening everyone. Thank you so much for coming along today. My name's Chloe Minto. I'm one of the solicitors at Government Law Centre, and I work specifically in the education law unit on the Let's Talk ASN project. Now, we are a project funded by the Scottish Government. We work in partnership with Barnardo's, and we provide advocacy and legal support service for families with a right of reference to the ASN Tribunal. So if you were to contact Let's Talk, we would help you through the reference process and we would guide you all the way through to the completion of the tribunal.
Great, thanks Chloe. And Iain, do you want to explain a bit about who you are?
Yep, thanks very much for having us here. My name is Iain Nisbet and I'm a solicitor at Cairn Legal, and Cairn Legal is sort of one bit of My Rights, My Say, in association with Partners in Advocacy, Enquire and Children in Scotland. So Cairn Legal is just a law firm. It specialises actually in helping families affected by disability prepare for the future, financially and otherwise. And we have a small education law department, which is where I work. And part of that work is doing the My Rights, My Say project. Again, that's a Scottish Government project. It's a statutory support service, so there has to be one of these support services. And it's for children aged 12 to 15. So that children before they become young people at age 16 who have those rights in law under the additional support for learning legislation to do things like request a CSP or request assessments, to engage in their learning and so on, to support them in doing that. And specifically the part that I'm involved in is in terms of legal representation. So for those cases that require to go to the tribunal or otherwise involved in legal dispute resolution, that's where I would get involved and provide the representation to support children to make that reference to the tribunal. You'll see there that I've used the term additional support needs tribunal. That's actually what the tribunal used to be called. It's now got a much longer name, which is the first tier tribunal for Scotland Health and Education Chamber, but we still call it the additional support needs tribunal as a sort of a descriptive term. So that's probably the easiest way to go about it, and that's, you'll see that lots of times. It's the same tribunal with a new name.
And thanks, Iain. So in terms of the aims of the session today, so I know we've got a real mix of families in this kind of virtual room. So some of you have got children in the early years, all the way up to people whose children are reaching school leaving age, and really broad range of different types of support needs. And hopefully all of you will get something useful out of the session today. Our plan for this evening is to basically explain the key things that you need to know about the tribunal. So I'm going to be covering a bit about the types of disputes that the tribunal can address. Then Chloe's going to talk through making a reference or claim to the tribunal. And Iain will be talking about the next steps after that, so kind of going to the tribunal itself and how hearings work. And they'll both explain a little bit more about how their services can help children, young people and their parents and carers. We're then going to have some time for questions. So there's lots of you here, so probably not enough time for all of your questions, but hopefully some of your questions are going to be answered during the presentation bit, and then fingers crossed we'll be able to get to quite a few of your questions after that. And if we don't, then you can always get in touch with us afterwards for more advice or information if you need it. In terms of a bit of kind of housekeeping stuff, so the session is being recorded, as I said at the start, so it's going to be available on our YouTube channel in a few days' time, so you'll be able to watch it back if you want to relive the experience again. And we're also going to be sending out the slides and links to the key things that we mentioned after this event, so don't need to worry too much about taking lots of notes during the session, because you should get most of it afterwards as well. A few of the slides have got links to kind of relevant websites or fact sheets as well, so you'll be able to find more information on a lot of subjects there. And if you think of any questions kind of while we're talking, you know, if questions pop up for you, then if you could keep them until we get to the specific kind of Q&A bit, that will make it kind of easier to find them in the chat so we can get to them. And I think that is the kind of boring housekeeping stuff. So in terms of generally, what is the tribunal? So as Iain said, it has got a much longer name, but most people still refer to it generally as the Additional Support Needs Tribunal rather than, First Year Tribunal, Health and Education Chamber, Additional Support Needs Jurisdiction. And during this session, we'll probably just say the tribunal most of the time. So the tribunal is an independent and expert body that considers certain kinds of appeals and disagreements about additional support for learning. And the members of the tribunal will consider the arguments and the evidence that's put forward to them, and then they'll make a decision about what should happen next, basically. So one of the most important kind of first things to understand is when the tribunal can get involved, as there are quite kind of specific circumstances when you can go to tribunal. And this is often like the kind of stage where someone might get in touch with the Enquire helpline. So, you know, you might be speaking to us on the phone about a kind of wider issue, or sometimes people get in touch after receiving a letter, maybe with a decision that they don't agree with. And our helpline advisors might be explaining, you know, that one of the options available would be that you could go to tribunal. So one of the kind of first things to know really is that there are two main kinds of cases that can go to tribunal. So they're called references and claims. So we'll look at each of those in turn. So references are for issues that are related to duties in the Additional Support for Learning Act. So there's a deadline of 2 months from a decision or failure happening to make a reference to the tribunal, and that's for all these different kinds of references. And you can see on this slide kind of the different situations where you can make a reference. So I'll talk through a little bit about each of those. So coordinated support plans, as some of you will know, they're the kind of only legal education support plan used in Scotland. And you can make a reference to tribunal about local authorities' decisions about kind of most aspects of a child's CSP, really. So it can be disagreements over things like whether or not your child should have one, what the contents of the plan are, whether the support written into the plan is being delivered, or failure to review the plan within a kind of legal timescale. You can also make a reference about a local authority's refusal of some kinds of placing request, with a placing request being a formal request that's made to a local authority in some kind of permanent format, like writing, to place a child in a specific school, and that gives reasons why they should go to that school. So if you make a placing request and it's refused, you might be able to go to tribunal if the school that you're asking for was a special school or nursery. And included in that definition would be kind of specialist support bases or units that might be attached to a mainstream school because they come under the legal definition of a special school. And the tribunal can also hear appeals against refused placing requests to mainstream schools or nurseries if your child has got a coordinated support plan. Or also things like if they're currently being assessed for a coordinated support plan or one's in the process of being prepared for them. So they're, in those situations, the tribunal can also hear appeals for placing requests for mainstream schools. You can also make a reference about a local authority's failure to meet its duties to plan for your child leaving school. So that can be things like failing to pass on information about your child's needs to agencies that would be supporting them after they leave school, or failing to consider what support the local authority might make for your child after they leave school, and that's in their departments other than education, so things like social work or housing provision. And can also be failing to take account of information that's been provided by you or your child in the planning for them leaving school. And then finally, references can also be made about a local authority's decision about the capacity and well-being of a child aged 12 to 15 who wants to use their specific legal rights. So that includes decisions that a child aged 12 to 15 doesn't have the maturity and understanding, like usually termed capacity, to be able to use their rights, or that using their rights would have a negative effect on their well-being. And Hannah will probably post some links to fact sheets on some of those topics if you want to read up in further detail on those. So that is references. And I realise this is a bit of a whirlwind tour through, but as I said, there will be opportunity to read more afterwards and go back over this if you want to. So the other type of case is called a claim, and that refers to claims of disability discrimination under the Equality Act. So that can be for alleged discrimination that's occurred within the last 6 months. So some examples of discrimination might be where someone feels that a nursery, a school or local authority has treated a disabled pupil unfairly compared to non-disabled pupils. If a disabled pupil has been excluded for a reason that's directly linked to disability. Maybe if a disabled pupil has been refused entry at a school because of their disability, or if they've been put at a disadvantage because reasonable adjustments haven't been made for them. And then, so other than those kind of specific circumstances, the tribunal isn't able to look at kind of other decisions or failures related to additional support for learning. So as I said, it's really only mainstream schools if the child has got a CSP or one's kind of being developed for them when a refused placing request go to tribunal. Otherwise, that would go to a local authority's education appeal committee, and the same for appeals against exclusions. And also, kind of general, disagreements about support provision can't generally go to the tribunal unless it's related to kind of disability discrimination, say. And that doesn't mean that there aren't kind of available routes for being able to resolve issues or kind of challenging decisions in different ways. It's just that there are different options other than the tribunal. We won't be going into so much detail about them today, but Our fact sheet, which is called Avoiding and Solving Problems, has quite a good kind of summary of all the different routes available and when you can use them. So it's got information about options like mediation, independent adjudication, complaints routes, things like that. And our helpline team can also advise on specific circumstances anytime if anyone's unsure how to kind of take a specific issue forward. So that is kind of when you can go to tribunal. I'm going to pass on to Chloe now, who's going to talk about next steps of how to make a reference or a claim.
Great, thank you so much, Annie. And this really is a whistle-stop tour, and I think the important thing for everyone to take away is the details of each organisation and keep them banked and come to us with any queries. So I'll take you on another whistle-stop tour of how to make a reference or claim to the Additional Support Needs Tribunal. So we just want to go to the first slide. Okay, so when you're thinking about making a reference, the first thing that you have to ask yourself is, am I able to make this reference? And that's the first point we have here. Who can make a reference? So when we're looking at a reference, a parent of a child with additional support needs is one of the categories that can make a reference. And it's important to remember when looking at that you do not need a diagnosis. So you can make a reference if your child has additional support needs, but that doesn't mean that you have to have a diagnosis, okay? The second category of people are young people, aged 16 years or over, who remain in school education. And then we have the last category, which is relatively new, and that's children aged between 12 and 15 years who have capacity. Now, we've heard a bit from Iain talking about My Rights, My Say, and he's told us that there are two types of reference that 12 to 15-year-olds can take forward. And those are references in relation to coordinated support plans, or a reference appealing against the Education Authority's assessment of the child's capacity or well-being. And the takeaway point there is that children aged 15 and under cannot appeal a placing request decision. Okay, so once you've established whether you can or cannot take a reference forward, whether you meet the criteria to take it forward, the next thing that you should look at is the time limit. Now, with a placing request, you must submit your reference to the tribunal within 2 months from the date of the refusal letter. So, for example, if you receive a refusal letter today on the 22nd of March, you would have to have your reference lodged with the tribunal by the 21st of May. And that's 1 day before the 2 months, and you'll keep yourself safe by going on that basis. Now, if you put in your placing request today, the 22nd of March, and you don't hear from the local authority by the 21st of May, you would then be a deemed refusal. It would be a deemed refusal. They've not come back to you and said, this is refused or this is accepted if you're lucky. So at that point, you would then have 2 months from that date to take it to the tribunal. So it all sounds a bit odd when I'm flinging dates at you, but if you just break it down, if today you send it in 22nd of March, no response by 21st of May, okay, 2 months to get it in to the tribunal. There's another slight caveat to that, in that if you're looking to apply for your child to start school in August, if you apply before the 15th of March, so if you were to apply before the 15th of March of this year, you would then have you should then have your response by the 30th of April. If you don't have it by then that is the date that it becomes a deemed refuse. So the clock starts ticking, that 2-month clock, and it's the same with coordinated support plans. So you should submit your reference within 2 months from the date of whatever failure it is that's being referred to. Now, what I would say is that if you're progressing with your own reference, these are the time limits, but if you have a refusal letter and you realise, oh, I've missed that time frame, do still get in touch with either Let's Talk or My Rights, My Say because we can put that forward to the tribunal and we can explain, you know, if you misunderstood, and they may exercise some discretion. So don't immediately kind of shut down if you feel that that 2-month period hasn't been met. If we could just go on to the next slide, please. Thank you. Now, in terms of how you can make a reference, the reference form is on the additional support needs section of the tribunal website, and you have the website details there. Now, the form is about 24 to 26 pages long, I think. It is quite a long form, but it's very self-explanatory and it will guide you the entire way through. Now, the form will tell you as you go through what information you need to provide, and you'll see on the screen there an overview of what we think that you should try and put in with your form. First of all, if you're sending your form off to the Additional Support Needs Tribunal, make sure you've got it signed and make sure you have it completed. Now, you can sign it electronically, just type your name in, put the date, and make sure you've got the full thing completed. At this stage, you would also want to be trying to lodge all relevant documents in relation to the child's additional support needs. Now, I do say trying. If you can't, don't worry. There is plenty of time for you to lodge additional documents. But if you can try at the start of your case to get as much gathered together, you'll get yourself in order as much as helping the tribunal out. So whatever you have that you think is relevant, you can put in at this stage. The main things are you have to lodge a copy of the refusal letter that you're appealing. Now, obviously, if it's a deemed refusal, you won't have that, and you'll write that in your form that this is a deemed refusal. So, you know, don't kind of worry if you think I don't have a refusal letter. It's understandable. If it's a deemed refusal, then you won't. And another really important point is if you're applying for an independent school, so say you're applying to Donaldson's, then you would need to lodge with the tribunal a copy of the acceptance letter saying that they're happy for the child to go to that school. That's really important that you lodge that with your reference. Now, if you are lodging a reference in relation to coordinated support plans, then you should lodge a copy of the coordinated support plan with your reference. On the tribunal website, there is a guide to documentation that I would really recommend you have a look at. The tribunal don't want you lodging screeds and screeds of documents. It may be that you only require to lodge 1 page of a certain document. It may be that you think more is necessary. So do have a read up on that guidance and make sure that if you are submitting documents, they're in line with what the tribunal are expecting you to do. If we go on to the next slide, please. Thank you. Okay, so who can make a claim? We heard a bit about the difference between references and claims. So when you're looking at who can make a claim to the tribunal, this is a parent of a child or young person who is disabled or a young person who has capacity to do so. And I've just put a wee note there saying that a child of 12 years is presumed to have the capacity to bring their own claim, and that's unless the contrary is proven. Now, there are some examples that you may take forward a disability discrimination case. It may be in relation to a decision around admissions, exclusions, but generally who you'll be taking the claim against is the responsible body. Now, if we're looking at public schools, this would be the Education Authority. And in the case of independent schools, this would be the owner or the governing body of the school. Now, again, the next point you look at is, okay, can I take this claim forward? Yes, I can. Time limit. It's the very next thing you need to be thinking about. And, you know, I would be writing this date everywhere, putting post-its all over the place so that you don't miss this date. Trust me, I do it. So for disability discrimination claims, you're looking at 6 months from the date of the alleged discrimination, or where there is a continuing omission, then the alleged discrimination is still ongoing. So it'll be that 6-month clock ticking along. So 6 months, put it everywhere. Don't let it slip past you. And if we can move on to the next slide, please. Okay, and when you're looking at making a claim, you're going back to the same website, the tribunal website. And I really should say, if you have a good scroll around on the tribunal website, there are really useful resources on there that break down step by step what you should be doing. And there's a particularly useful guide in relation to disability discrimination claims. So you might want to download that, have it on your computer, tick it off as you're going, and make sure you're hitting all the points. But once you've got your claim form ready to go, you'll then send that to the Additional Support Needs Tribunal, and I've attached the email address there. Now, the only difference, and it is an important difference that you should bear in mind, the only difference between the reference and the claim when submitting them is that you also need to send a copy of your claim and any supporting papers to the Equality and Human Rights Commission. So there's the address there, or there's an email address that you can use there. So make sure and send that to them as well. There'll be a big reminder up in the tribunal website. So don't worry. I'm sure that you'll be prompted by the tribunal when you look at the information there. But again, I've just listed what information you might want to provide when lodging your claim. So it may be you want to provide some information showing that the child or young person has a disability, information showing that the alleged discrimination was connected to the child or young person's disability, information showing that the alleged discrimination was not justified in the case of indirect discrimination. And you can see that the other points there that I won't bore you by reading through word for word, but you can see there the types of information that the tribunal are looking for. And that really is it. It might be when you're lodging your claim or your reference form, you would like to do a paper apart. So it might be you feel that in your reference form, you don't quite have enough room to put down what it is that you want to say, and you want to attach another sheet and type out all of the information there. Make sure that you fill out all of the form, but you can write in that you're attaching an additional sheet, and just make sure that's really clearly headed up, and you can attach that on to your reference form. If we just pop over to the next slide. That's great. Okay, so just some things to remember when you're looking at getting your reference or your claim into the tribunal. It can be a lengthy process. The tribunal try and deal with cases as efficiently as possible, but with the nature of cases, it may be that there are some pauses throughout. So proceedings may be suspended while negotiations happen, while investigations happen. Things can happen along the way. So I think it's important to get your claim or your reference in as soon as possible and get that clock to start ticking, because it may be that you're waiting another couple of months before you get the result from the tribunal or the outcome from the tribunal. And that can be a long and stressful journey. So you're better getting that started so that you're not feeling under pressure. And discussions can go on whilst the reference is ongoing. And that's another point to make, is about mediation. You can request to have mediation, and that mediation can happen whilst the reference or the claim is at the tribunal. That's not an issue. And it's something that at the start of, when you're putting in your reference, say for example, it's for a placing request, you might think, actually, I would like to try and mediate on this, and let's see if we can agree upon anything whilst this is ongoing. You can carry that on. It doesn't mean that you can't take things forward with the tribunal. If we're opening a case at Let's Talk, one of the first things that we'll also do is send out a subject access request, and that's for the education records. Now, if that's something that you would like to do, you can contact our office. We can send you a template letter, and you can send that off to your local authority. Again, they may take a bit of time for the documents to be processed and sent through, so you're better getting that off sooner rather than later. And that will give you access to your child's education records. And it might be that there's some really important evidence in there that you want to provide to the tribunal. I would also say that at the start, even when you're lodging your reference, even before, start thinking about witnesses. It's never too early to start, canvassing with people what their thoughts are and what's going on, trying to find out where they're at. And then that way you can really go to the tribunal and you're really starting to get your ducks in a row. And when you're sending off your form, do let the tribunal know if there's any support that you require throughout. It may be that you require forms translated. It may be that you require them in larger print. The tribunal are very flexible. And if you have any supports that you think they can help you with, do let them know that in the reference form or when you're lodging your claim, so that you can get the best from the tribunal as possible. But yep, we're all in this together. Take down all of our details. Please do contact any or all of us. And I wish you the very best of luck.
Thanks so much, Chloe. So Iain, I'm going to pass over to you now for the next stage. So what happens after you've put in a reference or a claim?
Yep, so thanks very much for that, Chloe. That was a great explanation of the initial reference and claim forms that go in. Having done that, the first thing that happens in relation to a case that involves a 12 to 15-year-old child is there's a sort of a sift process. Because that legislation has particular requirements that it only applies to children who have capacity. There's a particular test around that, and there's this well-being test as well. So the tribunal has to satisfy themselves first. So in practice, what that means is that there will be a telephone conference call with the legal member for that tribunal, and the tribunal will want to satisfy itself that the child has the necessary capacity to bring a tribunal case, and that it's not going to be detrimental to their well-being to do so. Now, in fairness to local authorities, this has tended not to be an issue in most of the cases that we've been involved in, and so that tends to go through without too much trouble. There is the potential for that to become an issue that is disputed, and could require evidence about the capacity of the child and so on in some cases. So that's a sort of an initial hurdle that you have to get over. But just in those type of cases, if it's a parent bringing the case or a young person over the age of 16, then that's not a necessary step. There's a presumption that that those people have capacity to bring the cases. So the first sort of substantial bit of procedure then is the case statement period. And that is a period where the parents or child, first of all, has to put all of their case together. And there's three main bits to that. So that's any further documents that you want to lodge, in addition to anything that you've put in with your form originally. So if there's any further documents to be lodged, those go in on the case statement date. Also, a thing called an attendance form, where you're listing everybody who's going to physically be or virtually be at the tribunal, so that is it both parents? Both parents going? Is the child going to be attending? Are you bringing a supporter? Who's the representative? Are you bringing witnesses? Remember, you're generally limited to 2 witnesses for a reference, but up to 5 witnesses for a claim. So you would fill that attendance form in, and then the main thing, I guess, is the case statement itself, and that's really setting out your factual and legal case. So why is it that as a parent, as a child, you're saying that you should be successful in the case? Here's all the facts. This is what the law says, and that entitles me to the outcome that I'm looking for. So maybe that's a CSP that's been denied, or a place at the school that's been refused, whatever the type of case is. The case statement period is, in most cases, it's 4 weeks for the parents or the child, and then a further 2 weeks for the education authority or the responsible body to put in their equivalent documents. So any documents, their attendance form, and their case statement period, as well. So you've got this kind of first, the parent or child is putting in their case and all of the documents to support that. And then the local authority or responsible body would respond to that. Once you've got all of that, we know both sides of the case and what they are now, there will be a case management call. And that is a conference call. We've got the legal member from the tribunal, the chair of the tribunal, together with the representatives from either side. And this is really just a procedural discussion. So we're talking about, well, when are we going to have the hearing? How long is it going to last? What are the order the witnesses are going to be heard in? Lots of really just practical stuff in terms of how we get the case to its conclusion. One of the key things that's discussed at this case is, at this stage rather, is the voice of the child. And I must say that the tribunal is a really child-centered organisation. It's really very, very good at making sure that the child's views are front and centre in any claim. There'll be a difference depending on whether it's actually the child that's bringing the case, in which case that voice would be sort of evidence in their case, or if it's a parent who's bringing the case and the child's views are nonetheless taken, but not as a party to the case, as somebody who the case is affecting. And there's lots of different ways in which that can be done. And the tribunal are really flexible about that. They've got specific tribunal rooms that are set up with children in mind. They make extensive use of specialist advocacy services to go and take the views of the child and report back. Increasingly, just because of the way that things have been recently, use of video evidence, whether that's pre-recorded or live. And actually a number of children have found that's a much easier way to give evidence or to give their views than it would be physically turning up to a building they're not familiar with and that sort of thing. So there's lots of different ways in which that voice can be heard, and the tribunal is really sort of flexible about that. I had one child client who asked if she would be allowed to bring a support animal along to the tribunal hearing, and the tribunal hearing just sort of tentatively asked what kind of animal that she wanted to bring, but we're very open to that as an idea that would help the child to be relaxed in that environment and to give their views so the tribunal could properly take those into account. And then we're sort of progressing on to the sort of resolution of the reference. And actually most references and claims that go to the tribunal, if you look at the statistics, most of them don't go to a final decision. Most of them are withdrawn at an earlier stage. And that's probably good news. That usually means that there's been some kind of compromise or agreement, and the parent or the young person is happy to have the case withdrawn because things have kind of sorted themselves out. Sometimes a case might be dismissed, so if the case is not a case that you can bring for some reason. So Chloe was talking about earlier on, if you don't have that letter from the independent school saying that they're happy to have your child there, then you're not going to be allowed to proceed with that claim. If you've brought the claim out of time and you've not got the extension for that, then it might be dismissed for those reasons. But that's fairly rare, much more common that it's withdrawn. And then if it is to be determined, some cases can be determined without a hearing, so just on the paperwork. And that can happen for some kinds of cases that are really sort of fairly straightforward, so just a missed deadline in the CSP process, something like that, or where both parties have agreed that this is a case that can be heard without a hearing, and you can just go forward, allow the tribunal, the chair on their own usually, to look at all of the written evidence and the cases that you've put forward and take a decision on that basis. Or we can go on to a full hearing of the case where the three-person tribunal would sit and hear evidence from both sides, all of the witnesses, both parties, consider all of the documents and the arguments that are put forward by the representatives and come to a decision. Remember that the tribunal is a specialist body. So alongside the legal member sit two specialist members, people who've got experience of working with children with additional support needs or disabilities. And so actually, even though you might be putting forward a claim and you've got a particular sort of focus in terms of what's that about, often the specialist members have their own ideas about the questions and the sort of lines that they want to take and so on. And, there really is a depth of knowledge there. You can be absolutely assured that the tribunal members have read all of the papers that you've submitted. These can be hundreds and hundreds of pages sometimes, these bundles of documents, but they'll have read all of that and be ready to participate in the hearing, asking the right questions and coming to a determination. At the moment, all of these hearings are online, so it's something not unlike this, Teams. environment. It's a platform called Cisco WebEx that the tribunal use, but very similar. So you can share documents on the screen, but people are dialing in on video phone or from their computers to participate in the hearing. The tribunal are hoping in due course to move back to in-person hearings, but I think they might retain some ability to have witnesses who are far away, or child witnesses in particular who are not comfortable about attending in person to dial in by video. I think we'll see maybe some of those aspects retained, but moving towards in-person hearings again, probably sometime later this year, but very much the same role that's being fulfilled in terms of hearing the case and coming up with a decision on the outcome there. And the tribunal's powers include the powers to overturn the authority's decisions. So you could be looking at a placing request that's been refused. The tribunal do have the power to overturn that and to require the authority to place the child in that school, have the power to overturn decisions about the CSP, whether there should or shouldn't be one, the power to rewrite parts of the coordinated support plan, and in the claims field discrimination cases, powers to overturn exclusions and to go into things like staff training and rewriting policies and so on. So the tribunal can't award compensation. That's written into the legislation that governs that, but has a very broad range of powers that the local authority or responsible body have to comply with. So there's some real, I guess, teeth behind the tribunal system there. There is the possibility of review or appeal of the tribunal's decisions, but actually in most cases, the tribunal's decision will be the final one in any given case. There is a complicated system whereby legal aid is available for claims. So if you're bringing an Equality Act case, you can have legal aid and you can go to a solicitor of your choice for that if you qualify financially. For the reference side of things, there isn't any legal aid available. So, but what the Scottish Government do fund, as you've said, is earlier on, is these two services. So if you are a young person, age 16 or above, or if you're a parent bringing a reference, then Let's Talk ASN can provide free legal representation for you there. And if you're a child, age 12 to 15, bringing your own reference in relation to a coordinated support plan or a transition matter, then My Rights, My Say can provide that service as well. So although there's no legal aid, there's a sort of an equivalent service available. And actually it's not means tested. So in some ways it's more generous, although you don't get to choose your representative. You're stuck with Chloe or I in those cases, I'm afraid. So that's probably a good point to stop in terms of the overview of the rest of the procedure through the tribunal, and I think pass back to Annie for some questions.
And thanks so much, Iain. So yeah, we've got a little bit of time for questions, so we'll open things up for that. So if you can put them in the chat if you've got any questions, then I can read them out. Or if it's easier for you, you can use the kind of raise hand function on Zoom, and then we can ask you to put your audio or camera on to ask a question. If you are asking questions, we'd ask that you don't use the names of any specific children or staff or schools, just to kind of protect everyone's privacy. And there's obviously, a whole host of different things that myself and Iain and Chloe might be able to talk about, but we will stick just to kind of tribunal related questions to pick out tonight. If there are other kind of issues that you want advice on, then we've got some other outreach sessions kind of recorded on YouTube. And like I said, we've also got publications, and we've got the Enquire Helpline, and you can also get in touch with Let's Talk ASN and My Rights, My Say as well about any other kinds of issues. But what I'll do just now is I'll stop sharing my screen so that I can then have a look at the chat and see if we've got any questions that have come in. Yes, loads. Okay, let me just have a quick read, and I will pick some out. I mean, one of the questions was, what was the animal, Iain? Which is for the support animal that somebody wanted to take.
Well, I think she had in mind a dog, but ultimately she attended without an animal, and she brought some colouring in instead. So
Yeah. Great.
that is lower maintenance.
Yeah. Yeah. Right. So one question from Renee was, if you request a CSP and it's refused and you appeal and that's upheld, can you reapply in the future for a CSP? And if so, are there kind of time restrictions before you can do that? So Chloe, I will go to you first on that one.
Thank you. I could see Iain nodding there. I was going to defer to Iain. Iain, you can correct me if I'm wrong, but my understanding is what you mean, and you've been to the tribunal, it's been refused, so there isn't a CSP in place. Ordinarily, there would be 12 months prior to you being able to, mind you, I think I'm thinking about placing requests. There's 12 months from the tribunal decision until you can then appeal to the tribunal again. I don't see anything preventing you from asking for the CSP again. I think it would just be about when you can take that to the tribunal. And I think it would be that 12 months. Iain, I'm not sure what your thoughts are on that one.
Yeah, that's my understanding as well. So you can ask for a CSP as often as you like, but there is this 12-month delay before you can go back to the tribunal, having been back once. So you wouldn't be able to do another appeal for a year, but you could start the process of asking for a CSP again. I mean, I guess generally, unless something had changed, you might not expect a different answer. But you know, if there'd been a new diagnosis or some more evidence, or you know, the child's moving on to a different school or something like that, some kind of change, then it might be worth asking again.
So we've had a couple about kind of funding for kind of assessments for gathering evidence for the tribunal. So whether there's kind of funding available for kind of specialist medical or psychological evidence to be gathered for the tribunal to then consider. Someone that's kind of heard of parents in England that have paid, you know, thousands of pounds to pay for kind of specialist evidence, so that they feel like they can kind of win their case. Iain, I'll go first to you on that.
Yes, I mean, certainly I don't think that I would be saying that you definitely need independent specialist evidence. That's often not the case. The tribunal itself is a specialist body. So I think that's something you would have a chat with your representative about to see whether it's actually going to add any value to the case. Certainly that does happen in some cases. I do instruct you know, various witnesses, independent, to act. So in terms of the funding, if you're going under legal aid, so if it's a discrimination case and you've got legal aid in place, then you can ask the legal aid board for funding to cover things like that, and they may be persuaded that that's reasonable and necessary and not too expensive. Certainly nothing like £25,000 per child, and fund that sort of thing. In terms of the My Rights My Say project and the Let's Talk ASN project, unless things have changed very much since I was working at Govan Law Centre, that's not part of the Scottish Government funding, so that isn't available. So you would either be in a position of, I guess, the parents paying for it themselves, or you know, sometimes there's various charitable funds that might be persuaded to cough up for that sort of thing. The tribunal itself has powers to instruct an independent report. Now, it doesn't use them very often, but you know, if that's something that you can persuade the tribunal that is necessary in order for it to make a decision, then there are those powers for the tribunal to do that themselves. So that would be another option.
Anything to add, Chloe?
Yeah, I think the only thing I would add from a Let's Talk perspective, Iain's absolutely right. We don't have funding to be able to pay outlays for specialists, but I do think it's important, if you are considering instructing a specialist, to really think about what value it is that they'll add. A lot of the times you think, you know, just because they're a specialist doesn't mean that that will be the kind of the winning point. What the tribunal are looking at is a really holistic overview of what's happening in the education. And a lot of times with specialists that you're paying funds for, you're looking at, you know, perhaps one set of assessments that happen in 1 hour on one day. And that will mean that those assessments have limited evidential value. And the tribunal will take that into consideration, that the witnesses for the local authority or the other witnesses that we could get may have a better understanding of the child's needs as to how they present in an educational environment. So do bear that in mind before you go spending a lot of money. I'm not saying that they're invaluable. I'm saying that it's worth thinking about what they can add.
Yeah, absolutely. Thank you. So a question from Patricia. So she said, how do you work with a young person aged 16 plus who's at school, or with a child aged 12 to 15 with capacity with AS? I presume you mean Asperger's syndrome there, but I'm sorry if I've misunderstood. Who appears to have kind of good communication, but doesn't necessarily kind of grasp concepts and things like that. So I don't know if I'll go to you first, Chloe, there. So from the perspective from Let's Talk ASN, I suppose, with the kind of, if it's a young person age 16 or older.
Yeah, I mean, I think at the initial stages we'd be checking that they do have capacity, and no matter who we're dealing with as a client, whether they're 16 or whether they're 60, we'll ensure that the way that we're offering our service is tailored to the individual. Some people prefer phone calls, some people prefer email. Ordinarily, as part of the tribunal process, we have to do a witness statement, which can be quite a lengthy document where you say your witness's position, and sometimes we can send that out to people, or we could read it to them over the phone, do that in chunks. So it really will just be tailored to the way that they are, and it'll be a process of getting to know them, working out what works for them, asking them, and making it would be our job to ensure that they do grasp concepts, and making sure that we present the information in a way that's helpful. If we're looking at a 16-year-old as well, I would also be encouraging them to get an independent advocate as well, to make sure if they're not comfortable with sharing with me, that their advocate could perhaps speak to us as well if there were any issues. But I think Iain will be better for this question, given the my rights, my say category.
Yeah, go for it, Iain.
Well, I'm very fortunate to work with partners in advocacy and the specialist children's advocacy workers there who come from a variety of backgrounds, but have those specialist skills in working with children, and with children with additional support needs in particular. Very often that is pupils on the autistic spectrum, as well as other issues that may be in place. The test that is in place is, does the child have capacity? And so that's what the tribunal are looking at now. So it isn't necessary for the child to understand all of the ins and outs of the tribunal process and so on. What I'm looking for is, do they understand, if it's a school's case, the difference between the schools, are they capable of showing a meaningful preference, retaining the memory of that decision, that sort of thing. We would talk about plans, and what should be in the plan and so on if we're talking about a CSP. So there doesn't need to be a sort of a very in-depth knowledge or understanding around that, as long as the sort of basics are there. And somebody's raising the issue here about what if the young person isn't willing to engage, and that is an issue. Remember that there's a dual jurisdiction here. So the 12 to 15-year-old, if they don't have capacity, or if they're not engaging, or even if they just prefer to do so, then the parent can take the case on their behalf, and then the young person's views can be taken into account. You can also get non-instructed advocacy in terms of that, what are the children's views, where somebody would just be saying, how does the child appear to be getting on in a school context, or something like that. So there's lots of different options. It would be the same for 16 plus. If the young person doesn't have capacity, then the parent can take on their behalf. So it's not a case that we have to go down that route, and we've got to sort of crowbar it if it's not right, or if the young person, the child, just prefers not to, then there's the option for the parent to step in and do that instead.
Great, thank you both so much. I'm going to just squeeze in one kind of final topic, which is something that Chloe and I were talking about just before the start of the session, which was about witnesses and who can be a witness. I know that comes up sometimes in a bit of kind of uncertainty, say whether, you know, a parent can ask like a staff member at school or someone like an educational psychologist to be a witness if you know they work for the local authority that they're kind of appealing a decision against or something like that. So I wondered, Chloe, briefly, if you wanted to just explain a bit about how that works in terms of who can be witnesses, and then we'll kind of wrap up.
Yes, absolutely. So there is guidance on the Tribunal's website in relation to witnesses. You can ask anyone to be a witness if you think that they'll bring value, and that is important to remember in terms of local authority employees. It may be that it's difficult or challenging to get them to be a witness, but I would always be directing them to the witness guidance and reinforcing that they're a witness for the tribunal, not necessarily a party, but for the tribunal, and there will be put questions to them by both sides, and the tribunal members will also have an opportunity to ask them questions. Now, if you feel that you're having a difficulty in identifying suitable witnesses, then you can ask the tribunal to cite a witness. You'd be able to do this at a case management call, or you could do this by writing to the tribunal and making a request for them to do that. And you'd need to provide good reasons as to why they should be cited to give their evidence. Just remember along the way that for a reference, you're able to have 2 witnesses. That doesn't include the appellant. So the appellant is the person taking it forward. So a parent, for example, you can have 2 additional witnesses. So you're wanting to try and get the best witnesses that you can get. So if you think that there's someone that's able to speak on behalf of your child or the young person, then do try and contact them and go down the route of trying to get them on board. And if you're having difficulties, then please contact us and we can help you with that. We can badger away and see where we can get.
Great, thank you. Anything final from you, Iain, to add either on witnesses or any other?
Yeah, no, I think on that, there's, you know, often parents are like, yeah, we're going to bring the teacher along, or we're going to bring the educational psychologist along, with the idea that we're just going to sort of put them under the spotlight, and really give them a good grilling and their crack like they do in the TV. And I mean, that's not really how it works. So I would say there's a difference between, you know, maybe a class teacher who knows the child really well and is really sympathetic, but it would be awkward for them to sort of volunteer to be a witness for you. And under those circumstances, I think it might be worthwhile going down, well, we're going to ask the tribunal to cite that witness, because that sort of gives them the sort of, well, I'm not going because the parents asked me, I'm going because the tribunal has said I had to. It gives them a bit of, you know, makes it a bit easier for them to do that. But I think, you know, bringing somebody along as a witness who really doesn't want to be there, you're unlikely to get very good evidence from them. So I think there is a judgment call to be made there about actually what is the purpose of this? Is it going to be helpful, particularly, as Chloe's saying, when for references you are so limited in the number of witnesses that you have. So, you know, you would always be saying to somebody who's maybe not that keen to be there in person, well, actually, could you just write a letter of support and we'll lodge that, and then we'll get somebody else in as the witness who's going to be a bit more forthcoming. Something, you know, so there's options there in terms of how the evidence is given. You could just get a witness statement and lodge it and say, I'm not calling this witness. You know, there is a bit of flexibility in that as well. So it's definitely, there's a bit of sort of weighing up the options in terms of your witnesses as well. And sometimes the tribunal can grant, you know, there's a bit of flexibility there. You can get a 3rd witness if you can show a need for it, but generally speaking, you're restricted to the 2. So you do need to be careful that you're calling people who are actually going to help.
Thank you both so much. So that's us at our time. So thank you so much to Iain and to Chloe and to all of you for coming along. You can see all our contact details, hopefully, on the screen there if you want to follow up anything with any of us. As I said, this has been recorded, so it'll be up on YouTube in a few days' time. And we'll also be sending out kind of links to fact sheets we've mentioned, links to websites, things like that. We'll also be sending a link to an evaluation form, so it would be really amazing if you'd be happy to fill that out, just so we can see if this type of session works for you, you know, if you found it useful, things like that. You can look out on social media or in our newsletter for details of future sessions like this as well. But for now, I'll just say thank you so much again to Iain and to Chloe and for everyone for coming along.